Your Honour, if it pleases the Court, my name is Olivia Linnett, Special Counsel appearing for Mr Otto Lowtower. This morning I seek a pre-trial ruling under section 590AA2E of the Criminal Code of 1899 Queensland to exclude all evidence obtained as a result of the vehicle stop conducted by Detective Senior Constable David Tarragon on the 1st of June 2024. Firstly, Your Honour, I would like to point out the illegality of the stop. The Crown would have us believe that the stop conducted on the 1st of June was merely intended to check Mr Lowtower's licence as enabled under section 60 of the Police Powers and Responsibilities Act of 2000, Queensland, otherwise known as the PPRA. With the greatest respect, this is a gross misrepresentation of the facts. Detective Tarragon did not stop Mr Lowtower's vehicle to perform a routine licence check. He stopped the vehicle with the intent to further an ongoing investigation into the Green Traders outlaw motorcycle gang. Under section 31(1) of the PPRA, the search must be relevant to the circumstances for which the vehicle and its occupants are detained. Further, under section 31 subsection 2 of the PPRA, it stipulates that police have the permit to search a vehicle only if they have reasonable suspicion that the vehicle is being used unlawfully. George against Rocket defines reasonable suspicion as a suspicion that is grounded on more than just conjecture. It must have a factual basis. Cloaking investigatory inquiry as a routine licence check, as Detective Tarragon did in this case, fundamentally breaches the purpose of the PPRA. Looking at the facts, any reasonable person can see that the primary goal of Detective Tarragon was to investigate, not to regulate. Not only was the guise of a routine licence check to conduct a baseless search a blatant exploitation of the statutory powers bestowed under the PPRA, but an insult to the rule of law. The recent decision of the Crown against Swain highlights the importance of strict adherence to the statutory intent of the PPRA. The Queensland Supreme Court emphasised that for a search to be lawful under section 31 of the PPRA, there must be a clear and reasonable suspicion grounded in factual information. The court found in Swain that the actions of the police officers were unlawful as they conducted a search without establishing a connection between the defendant and the vehicle. Applying this to Mr Lowtower's case, Detective Tarragon failed to establish a factual link between Mr Lowtower and the vehicle, as he is not the owner. The Crown would argue, Your Honour, that the information provided by the Q-Light system, specifically the Crime Stoppers tip, was enough to amount to reasonable suspicion. I wish to highlight, Your Honour, that the allegations against Mr Lowtower in this tip were merely that there were multiple arrivals and departures of people at odd times to a suburban property. Without further context, this could simply indicate a social household, which is far from sufficient to amount to reasonable suspicion. Even if there was reasonable suspicion to search the reported property, the search in question here is of the vehicle Mr Lowtower was driving, which had no direct link to the alleged suspicious activity. Moreover, it is crucial to note that at the time of the stop, Detective Tarragon did not know who Mr Lowtower was. He did not see any drugs, nor did he observe a green trader's vest, factors that might have led to reasonable suspicion. Instead, Detective Tarragon was operating on a baseless hunch. It was only after conducting his fishing expedition, disguised as a licence check, that he confirmed his unsubstantiated suspicion. Your Honour, this falls short of the standard required by law. The Court has a duty under section 130 of the Evidence Act of 1997 Queensland to exclude evidence if it was obtained unlawfully or if its admission would compromise the fairness of the trial. In this case, the evidence obtained by Detective Tarragon was not only obtained unlawfully, but obtained in direct contravention of the principles that police are to abide by. Hypothetically, if the court were to find that the stop and Bunning against Cross set the tone that the courts must protect the integrity of the judicial process from the consequences of unlawfully obtained evidence. Your Honour, the court should exercise its public policy discretion in accordance with Bunning against Cross to exclude evidence obtained by Detective Tarragon for several compelling reasons. Firstly, the conduct in question resulted from a deliberate breach of the statute, as Detective Tarragon manipulated the powers under Section 60 of the PPRA to further an investigation. Secondly, the evidence obtained is not of significant probative value to the Crown. Unlike other cases involving perishable or transient evidence, the circumstances were not pressing. Detective Tarragon abused his powers to cut corners to further the Green Traders investigation. Your Honour, Mr. Lowtower's case involves a single charge of possession, which is hardly a serious enough offence to justify the admission of unlawfully obtained evidence. Admitting the evidence obtained from the vehicle Mr. Lowtower was driving would send a dangerous message that police can misuse their powers with impunity and that courts will tolerate such conduct. This is not a question of fairness to Mr. Lowtower, it's about safeguarding the fundamental principles of Australia's justice system. For these reasons, I respectfully urge the court to exclude all evidence obtained as a result of the vehicle stop.